Okay. Hi, everybody. Thank you for joining us today. This is the Immigration Options After Graduation Workshop. And just wait another few minutes while people join. So my name is Beth Brooke, and I'm an International Student Advisor here in the VIS office at Stony Brook. And I just wanted to thank everybody for joining us today. We have a special guest speaker, one of our favorite lawyers, Brendan Venter. Brendan is an experienced immigration attorney with the law firm of Harris Beach. They have offices in Albany and Manhattan. Brendan serves as immigration counsel to Stony Brook University as well as other SUNY schools in New York. Brendan will be talking with you all today about immigration options after graduation. He has prepared an informative presentation that he will go through, and then at the end, we'll have a brief question and answer session. So this workshop will be recorded and posted on our website for reference. Now, because this workshop is being presented as a webinar, we're going to ask that you please submit your questions using the Q&A feature and not the chat. As a reminder, please keep your questions general and save your case-specific questions for your VIS advisor. So without further ado, Brendan, I'll hand it off to you.
All right, thank you very much, Beth. And I want to start by thanking SUNY Stony Brook and the VIS office for hosting me here. We give this presentation every year. We've done it the last 3 or 4 years or so. And normally my colleague and I get to make the drive down to Long Island to see you all in person. But unfortunately, that wasn't in the works this year. But I'm glad we're still able to make this happen and still able to hopefully give you all some helpful information about what your visa and immigration options may be after you graduate. So I will share my screen here so we can get the presentation going. Okay. So just as a kind of a preamble to the presentation, as Beth said, this is going to focus on visa and immigration options after graduation. So while we certainly deal with F1 student-related issues, your best friend for those sorts of issues are going to be the DSO or your international student advisor at SUNY Stony Brook. They're the ones who are the experts in F1 issues and how to report certain things in CVIS. So they're your best friends for F1 issues. What this presentation is going to focus on is after that. So after you graduate, after your time as an F1 student is done, where can you go from there to be able to remain in the US and to do what you'd like to do? So taking kind of a 10,000-foot view of how our US immigration system works, there are 3 basic groups that people will fall into. There are some exceptions to these, for example, people seeking asylum or refugee status. But in 99% of cases, someone's going to fall into one of these categories of group, individual or of process that they're pursuing. So we have non-immigrant visas, which are any temporary visas that have a specific duration and a specific purpose for the individual to pursue in the United States. So an F1 student visa is an example of that. It's a temporary visa that allows someone to come to the US for a temporary period of time to study, to attend college or university. There are other types of non-immigrant visas, which we'll talk about in a lot more detail, that would allow someone to do other things in the US, such as remain here to work. Kind of going the next step from a non-immigrant visa would be an immigrant visa or a lawful permanent resident. So that's someone who's no longer in a temporary status. It's actually a permanent status. They're a resident of the United States. They can live here, they can work here, and it gives them a lot more flexibility in terms of what they can and cannot do. their purpose in the US is not so specific as it would be on a non-immigrant visa. And we'll talk about some of the green card categories and processes as well later in the presentation. Finally, we have US citizenship, which generally is accomplished through the naturalization process. So once somebody has been a permanent resident of the US for a certain period of time, they then would become eligible, if they want to apply for US citizenship through naturalization. There's no requirement that a permanent resident do that. Someone can remain a permanent resident for the remainder of their life if they want to. So there's no obligation to naturalize to US citizen, but it is an option for some people once they've been a permanent resident. So this kind of is another overview slide, which gives you a high-level view of the different categories we have in our US immigration system for non-immigrant visas as well as immigrant visas or green cards. Once someone becomes a green card holder, a permanent resident is a permanent resident. There's really no difference between the end result. The difference comes in when looking at the process one would take to get to permanent resident status, or the category they would go through to get their green card. Non-immigrant visas, again, are different because each of those has a specific set of rules attached to it. So we've listed some of the more common ones here. There are more that are not listed here. There's basically a non-immigrant visa for every category of the alphabet. And as you can see with the explanations attached to them, they all have a different purpose. They all have a different activity that the individual can do while in the US, or different type of work they can engage in. So we're going to talk about some of the more common ones that you may be likely to encounter or possibly be a candidate for once you graduate. So again, we're not going to talk too much about F1 student visa related issues, but I included a couple slides here just if you're totally new to this game, to kind of give you a sense of what some of the work authorization options would be for F1 students. So first you have what's called optional practical training, which is 12 months or 1 year of work authorization that F1 students can get beginning when they graduate. So it's 1 year kind of as work authorization to allow them to transition out of being a student and potentially into some sort of work visa. The major limitations on OPT are that the job you use, or the job you find to work in using your OPT must be related to your degree program. So you can't use OPT to work in a position that's totally unrelated to what you studied on your F1 visa program. Beyond that initial year of OPT, there is for some students an additional 2 years available to extend your OPT, what we call the STEM OPT extension. So this is limited to students who have earned a degree in a STEM field, science, technology, engineering, or math. So you have to kind of check the code assigned to your degree field against a list that ICE, Immigration Customs and Enforcement, publishes as to which fields are eligible. And if your degree field is on that list, you may be eligible for a STEM extension. The other limitation to keep in mind is that this is only available to work at employers who are enrolled in E-Verify. E-Verify is a federal government program that employers can use if they want to, but they're not required to as of now. So some employers do participate, some do not. So if you want to use this additional 2-year extension of OPT to continue working, as of now, it must be for an employer enrolled in E-Verify. So we're going to start and devote a lot of time to what's called the H-1B visa. And the reason for that is the H-1B is probably our most common, what we call our workhorse visa in the US. It's the typical visa that individuals will pursue to work in the United States in most professional positions. So if you look at the first column here, we go through some of the primary requirements for the H-1B. So the major one is that this is not available for all jobs. It is limited to positions that are what the government calls a specialty occupation. And there's a complicated definition they use for what is and is not a specialty occupation. Really what it boils down to is that the position must be one that requires, at minimum, for an entry-level position, a bachelor's degree or higher in a specific field. So, for example, a job category that's been problematic over the years is computer programmer. So, computer programmer, according to the US Department of Labor, is a job that frequently individuals can qualify for with just an associate's degree, a 2-year college degree. So because the Department of Labor has said that is a normal or a common requirement or qualification for that job, computer programmer is a challenging one to get qualified for an H-1B because it's not generally viewed as a position that requires at least a bachelor's degree. So kind of where the attorney comes in this process is we help employers evaluate whether the position falls in a category that is likely to qualify as a specialty occupation. Some of these rules are kind of changing as we speak. So there is a proposed rule currently in the works that is set to take effect early December that would restrict the definition of specialty occupation even further. So right now, as long as we look at requirement number 2 here, the applicant must have a degree equivalent to a US bachelor's degree in a field that's related to the position. So if you have a bachelor's degree in finance, you're probably not going to be able to use that to take an H-1B or get an H-1B visa for a position as an art history teacher, because those are not related. So the degree you've obtained has to be, as of now, closely related to the occupation you're seeking. The proposed rule that will be taking in effect potentially in a few weeks would change that requirement to go from closely related to directly related. So they're clamping down on this. They're trying to make it even more restrictive and even more challenging to qualify for an H-1B visa. Some of these proposed rules are a bit uncertain at the moment because they're not in effect yet, and there are several lawsuits pending challenging them. So different industry groups and employers have sued the federal government alleging that these new rules are illegal. So that's yet to be seen as to whether they're actually going to go into effect or not, but I just mentioned them so you kind of have them on your radar. And another main requirement of the H-1B is that the employer must pay what's called the prevailing wage. So there is a set minimum wage beyond just the state or federal minimum wage levels that employers must pay for H-1B workers. And these are set based on different averages of what other workers in that occupation, in that geographical area are earning. So the Department of Labor sets a floor that they say H-1B workers in this type of position in this geographical area must be paid at least this amount. So that is a requirement the employer must comply with. H-1B visas, if they're approved and granted, you can get them for up to 3 years at a time. So if it's approved, you can get a 3-year period of H-1B status, which you can then renew for an additional 3 years for a total of 6 years. That 6 years is in many cases a hard stop. So you cannot continue extending your H-1B beyond that 6th year with some limited exceptions, which we'll probably mention later on. Basically, if your employer has started a green card process for you, a permanent residency process, and you get far enough along in that process, then there is an exception to that 6-year H-1B limit where they can continue extending your H-1B beyond the 6 years while you wait to finish the green card process. But generally, it is limited at 6 years. So Usually what I recommend is if my clients get an H-1B position, they get an initial H-1B approved for 3 years. If they haven't already, by the time they're looking to file that extension for the second 3 years, it's a good idea to have a discussion with the employer about a green card process and starting that, because you don't want to wait until you're in the 5th year or you've got 6 months left till you reach the 6th year to think about a green card, because at that point it's probably going to be too late to get your green card in hand before you max out of H-1B time. So getting an H-1B is great. That's the first step to kind of a long-term strategy here in the US. And what you want to do is always have in the back of your mind what the next step is going to be, which typically from an H-1B, a lot of times the next step is a green card, which again, we'll talk about later. So again, some of the basics, we mentioned this issue about specialty occupation. Must be a job that requires a bachelor's degree at least in a specific field, and the employee or the beneficiary must have a degree that's closely related to that occupational type. There must be an employer-employee relationship, so you can't do this as an independent contractor. The employer has to hire you on a W-2 with a legal employer-employee relationship. H-1Bs are employer-specific. What that means is if your employer files an H-1B petition for you and that gets approved, you are only authorized to work for the employer named on that petition. So you can't use your H-1B status to go work wherever you want. It's limited to a specific employer. Now, there are some cases where people will have more than one employer. So you may work part-time for employer A and part-time for employer B. If both of those positions, or each of them, I should say, independently would qualify as a specialty occupation, you can have what's called concurrent H-1Bs. So employer A and employer B could each file their own H-1B petition for you. And once you have both of those approved, you could work for both of those employers simultaneously. But they are employer specific, so they don't give general work authorization. It's only for the employer who actually filed for you. Off-site placement is okay, meaning employer A petitions for you, they're going to be your employer, but you're actually going to work at their client, the site of their client. So this is common in a lot of IT positions where they'll have IT consultants or software developers who are employed by a company that does IT consulting. And that company in their business, they place their workers at their client's site to actually perform the work. So that's okay, as long as the petitioning employer remains your employer and they're the ones supervising you and evaluating your work. But one of these proposed rules that is set to potentially take effect next month would limit the duration of H-1Bs for offsite placements to 1 year. So you couldn't get that full 3-year approval if you're going to work anywhere other than the employer's site. You'd be limited to 1 year at a time. So one of the main issues, you may be thinking so far, okay, the H-1B sounds great. We'll just go ahead with that because I'm going to have a bachelor's degree. I'm going to work in a job that's related to my degree. So there should be nothing holding us back from getting an H-1B. The big thing that holds a lot of people back is this issue of the numerical cap or the numerical limitation. So H-1Bs are limited in number each year. There's not an unlimited supply. There's a total of 85,000 H-1B visas that are distributed each year when the new government fiscal year begins on October 1st. 20,000 of those 85,000 are reserved for individuals who have a master's degree or higher from a US college or university. And the remaining 65,000 are for everyone, everyone else, basically. Now, what happens is there are many, many more than 85,000 people every year who want to get an H-1B. For the last, I would say, 7 or 8 years or so, the number has been over 200,000 or close to 200,000 who actually apply for H-1Bs. So the way that the government distributes these is it's not first come, first serve. As of now, what they do is they conduct a random lottery. So around the beginning of April every year, any employers who want to seek an H-1B visa for their employees or prospective employees will enter this lottery, and they'll submit an online registration where they say, here's the employer's information, here's the employee's information, here's the job we want them to hold. And they submit that registration electronically. Within the first couple weeks of April, the USCIS, US Citizenship and Immigration Services, they take all of those online submissions received, and they spin the wheel and conduct a random lottery, and they pull out 65,000 or 85,000, we should say, submissions who win the lottery and get selected for one of these limited visas. Now, getting selected in the lottery doesn't mean the petition is approved. It just means you can then go ahead and actually submit the H-1B petition. If you submit a submission in the lottery and you're not selected, you can't even file the H-1B petition. So you were not selected. There's no potential visa available to you as an H-1B that year. So right now it's random, and for the last dozen years at least, it's been random lottery. There was recently, again, keeping with this theme of changes in the immigration system, there was a proposal submitted recently to change the system and to allocate H-1B visas, not randomly, but to do it based on the salary paid. So basically the highest paid H-1B workers would be the ones who would be selected for these limited numbers. And if you're towards the lower paid range, you would not be selected. So again, that's a proposal that is not definite yet. There are already challenges in the works to that rule as well. So that's kind of something we're keeping our eye on to see if that's going to go into effect, and if it does, what the details are of that. But again, I just mention it so you're aware, and we are kind of anxiously awaiting to see what the end result will be with that. So let's see. Okay, one exception, an important exception to these H-1B numerical limitations is for college and university personnel, meaning employees of colleges and universities. And this is not just faculty, but staff as well. So that 85,000 limit on H-1Bs is the general rule. There's 85,000 available, and they do this random lottery to select. There are certain types of employers who are exempt from those numerical limitations, meaning they can file H-1Bs at any time of the year, even if all 85,000 are used up. These employers are exempt from that lottery. So a big one is colleges and universities. Any college and university in the US may file an H-1B petition for an employee at any time and not have to deal with that lottery, and not have to play the odds of getting selected for one of those limited numbers. So that's a huge benefit because it takes out a lot of the uncertainty. For non-exempt employers, ordinary employers, they have these dual levels of uncertainty. First, are they even going to get selected in the lottery? And you have to get past that threshold first to even submit the petition and see if it's going to get approved by USCIS. So if you're looking for jobs and you're in a field that has potential opportunities at a college or university, this is a significant benefit for you to be aware of when you're evaluating what your options are and what job opportunities are available. Because going to a college or university to work, they'll have a much easier time of getting you an H-1B than an employer would in private industry. So I think it's important for you to be aware of that. In addition to colleges and universities themselves, there are other entities that are exempt from the numerical limitations also. So the primary ones would be nonprofit organizations that are affiliated with colleges and universities. So we see this a lot, for example, for nonprofit hospitals or healthcare organizations that have an affiliation with a med school for a residency program. So there's an affiliation for the med school to send residents to this hospital to do medical training. That affiliation, that agreement between the two entities makes the hospital exempt from H-1B cap, the H-1B lottery, and not necessarily just for the residents themselves, but just the fact of having that affiliation makes the nonprofit entity exempt. So that's another thing we often explore for nonprofits to see if they may be exempt from this. And the other big one would be a nonprofit research organization or a governmental research organization. So if you have an employer whose primary mission, primary activity is research, and it's a governmental entity or it's a nonprofit entity, they can potentially claim an exemption from the H-1B cap. If it's a for-profit entity, then they're not going to qualify for that exemption, and they'll just have to go through the H-1B lottery. So you have this issue of cap subject employers versus cap exempt employers. And obviously cap exempt is going to be easier to get because they don't have to go through the lottery. One thing to keep in mind, if you do take a position with a cap exempt employer and they get you an H-1B, if you down the road seek to change employers and you want to go from, so you've got your H-1B status, you're working, let's say, for a college, and 2 years later, you decide to change jobs and go to a job in private industry that's not affiliated with a college or university. And that employer is not exempt. So that employer would be ordinarily subject to the lottery. If you want to make that change, in order to do that, you would have to be selected in an H-1B lottery to qualify for that change of employer, because you're going from an exempt employer to an employer who is subject to that lottery. If you're going from one exempt employer to another, it's no problem. You don't have to go through the lottery. So if you're going from one college to another college for work purposes, basically the new employer just files an H-1B transfer or a change of employer, and you're able to start working for that new employer without dealing with the lottery. So just keep in mind, going from exempt to cap subject, you have to keep that lottery in mind. And if you never had gone through it before, if you've never been selected in the lottery, you're going to have to do that before you'd be eligible to start with the new employer. So because of that uncertainty and the limitation on the H-1B, a lot of times what we do is try to explore our alternatives. So the H-1B in many cases is the best option, but in a lot of cases, there are other options we can pursue that don't involve the uncertainty of that lottery. So I've listed a bunch of them here, and I'll talk about a few of these in a little bit more detail. The first I'll address is what's called a TN visa. So this is very similar in many ways to the H-1B, in that most of the positions that qualify are ones that are professional positions that will require at least a bachelor's degree in a specific field. The differences with the TN are, first, there's no numerical limitation, so no lottery, so that's a good thing. One of the restrictions on it is it's limited only to Canadian and Mexican citizens. So if you're not a Canadian or Mexican citizen, the TN is not an option for you. But if you are, it's a good option that we will oftentimes pursue because you can avoid the H-1B lottery. The other limitation to keep in mind is the TN visa was created through the NAFTA treaty between the US, Canada, and Mexico, the countries of North America. And in that treaty, they have listed all of these specific professions that will qualify. So the H-1B, sometimes there's room to argue that a job is or is not a specialty occupation. With the TN, there's less flexibility because all of the professions that qualify are specifically listed in the treaty. Most professions appear there, but not all do. So, a lot of times we'll look at that list to see if a potential job opportunity is one that's going to qualify or not, but it does have to appear on that list for you to be able to qualify. Similar to the TN, there are other visa types that were created by free trade agreements between the US and other countries, and they're substantively very similar to the H-1B visa. So for example, we have what's called an H-1B1, so we add that additional one at the end. These are specifically for Chilean and Singaporean citizens. So if you're a citizen of Chile or Singapore, you can get this special type of H-1B basically. These are numerically limited like the ordinary H-1B is. The difference is the cap on these is basically never reached. So while there technically is a limit on the number, we never reach that number. So for all intents and purposes, these types of visas are generally always available, and you don't have to worry about going through a lottery system. It's kind of the same thing for Australian citizens. It's just called an E3 visa and not an H-1B1. So again, the position has to be a specialty occupation. The beneficiary has to have a bachelor's degree in a field related to the offered position. And the employer then would petition for that employee to get an E3 visa, but again, it's limited to Australian citizens. So similar to the well, not similar to the E3, similar in name to the E3, we have what's called an E2 visa. So now we're going to kind of start to explore the other visa options that aren't necessarily just for positions that require a bachelor's degree. E2 visas, like the E3, were created or are created by treaties of trade and commerce that the US government has with various countries around the world. So E2s are available not just for a specific country. There's a long list of countries that qualify for E2 visas. There are some notable exceptions to that, or notable omissions. So for example, China and India being the big ones, they do not have these treaties of trade and commerce with the US. So Chinese and Indian citizens cannot get E2 visas as investors. But E2 visas, as the name says here, for treaty investors, basically what they're for is someone who has or will be investing in a business in the United States, and they're seeking a visa based on that investment so that they can come to the US or remain in the US to direct and manage that investment. So this really can be any type of business. It can be, I've done a lot of E2s for pizza shops. I did one for a leggings store in a mall recently. I did one for a photographer, a videographer. So it really is very flexible. If you're kind of an entrepreneurial spirit and you have the ability to invest in a business in the US, and by invest, that can either be purchasing an existing business. So if there's a company or a business that's operating and they're selling, and you want to kind of come in and buy that existing business, or it can be starting up a new business where there's none had previously existed. You're just starting a new entity, getting it going off the ground. Either way works if you're willing to make an investment in that business so that you can direct and manage it. Now, a lot of times for E2s, potential clients will ask me, how much do I have to invest? That's usually the key question. How much do I have to spend on this? There's no minimum dollar amount in the law. It's really determined on a case-by-case basis, and they're going to look to see, is the investment substantial? And what is or is not substantial is going to depend on the circumstances. So for the pizza shop I mentioned, and a smaller investment amount will be substantial because you don't need that much to make pizzas and sell them over a counter. You buy or lease some ovens and some refrigerators, and you purchase the ingredients, and you lease out a space, and that's pretty much all you need. So you don't need a tremendous investment for those. Whereas if it's going to be a huge manufacturing enterprise, the investment you're going to need is going to be much more substantial or much higher. So these are kind of one of my favorite to work on. They're always very interesting. But obviously there, going to be a unique circumstance where someone has the ability to make this sort of investment in a business in the US. But it's just something to keep in mind as, maybe not right when you graduate from school, but down the road, if you have the ability to make an investment, this is a good option that not a lot of people think about as kind of an out of the box option to be able to stay in the US. It doesn't require you to find a formal job offer. You basically can do this on your own for a position that you create or a business that you create. So it's more in your control than some of the other employer-based visas are. Another visa type that we see quite often is what's called a J1 visa. So these are for cultural exchange visitors. I'm not going to go too much into the details of J1s because I could probably do a whole presentation on these given how many different categories there are. But you can see in the bottom set of bullet points here, there are a lot of different categories of J1 visas. So they kind of have a big range of what someone can do on a J1. So this would be something, you could speak with employers about to see if they have an established J1 program and what types of J1 visas they've been able to issue in the past. And I'll skip this slide. One thing to keep in mind with J1s is that depending on the type of program you start on or you work on a J1, some of them can subject you to what's called the 2-year home residence requirement. So for example, if you're on a J1 program where you received funding from the US government or your home government for the program, a common example we see of these is Fulbright scholars who get funding from the Fulbright organization. If you get government funding, that's going to subject you to this 2-year home residency requirement. Another one would be what's called the skills list. So each country has designated a certain set of skills or categories of J1 programs where they've said if someone from their country participates in a J1 program in one of these categories, they will become subject to the home residency requirement. And what that means is before you'd be eligible to change to most other visa statuses, aside from J1, or before you'd be eligible to get a green card, you would have to either go back to your home country for 2 years or obtain a waiver of that 2-year requirement. The whole thought process behind this is because the J1 is a cultural exchange visa, they want the idea of the J1 is that individuals can use it to come to the US to participate in a program, to learn skills or to learn about culture in the US, and then to come back to their home country to basically share what they have learned. So the home country is supposed to get some sort of benefit out of this program, and to ensure that, some of the programs require the J1 visa holder to go back to the home country for 2 years before they can remain in the US, either on a different status or as a permanent resident, a green card holder. And I think the last visa type we'll touch on is what's called an O1 visa. So O1 visas are for individuals who have extraordinary ability. And it can be in any one of these fields we've listed here: science, education, business, or athletics. So if you're someone who you're getting your PhD in biotechnology, and during your PhD program, you've published journal articles and your works have been cited and you've presented at conferences, and you've reviewed manuscripts submitted to journals, done peer review work, and you've won awards in your field. So if you've done a lot of research work, you've really established yourself as someone who's made contributions to your field and sort of gained some level of recognition or notoriety within your field for that, you may qualify for an O1. So they require, as we state here, national or international acclaim. So regardless of the field, you have to show that you've made a significant contribution to the field. You've basically done something or things that have made you well known in your field. Other people know who you are, other people are aware of your work and may have used your work or benefited from it somehow. So this isn't just kind of an ordinary person. You really do have to show, as the name implies, that you're extraordinary. So these can be challenging to document. The list here has the different categories of evidence that we generally try to gather to show that someone is in fact extraordinary and has received this recognition in their field. But they're quite extensive in terms of the documentation that's required. So it's not just submitting your CV, but it's submitting, documentary evidence to prove all of these things. Printouts of articles about you, printouts of interviews you've done, copies of any publications you've authored, so things like that. But the O1 can sometimes be an option depending on the person's field. Some fields are easier than others to pursue an O1 just based on the nature of what people are doing. But if you're someone who's had a lot of success already in your field, the O1 is an option to consider if none of the others work out, like an H1B. So just check my time here. Okay, so we've got a few minutes before we'll open it up for questions. So kind of this part of the presentation, we've touched on some of the non-immigrant visas very quickly. What I'm going to touch on now quickly are the immigrant visa or the green card processes. So again, the difference here is immigrant visas or green cards give someone a permanent status in the US. So they're not temporary like the non-immigrant visas are. And once you get your green card, you're really not restricted in terms of what you can do for work purposes. H-1Bs, you can only work for the employer who petitioned for you, and it has to be in a specialty occupation related to your degree. Once you get a green card, you can work wherever you want in whatever type of position you want. It does not have to be related to your degree. You can work for multiple employers. You can not work at all if you want and still remain in status. So it gives you that permanent status that's not really necessarily tied anymore to what you're doing in the United States. So as you'll see here, there's basically two primary ways to get a green card or become a permanent resident. There are some other ways that aren't mentioned here. For example, asylees or refugees. So if someone's seeking protection in the US from persecution they may face in their home country, that's another path to a green card, but we're not going to talk about that in this presentation, nor are we really going to talk about the family-based categories, but I'll mention it just because it's out there. So if someone has a relative who is a US citizen or green card holder, depending on the relationship, that individual may or may not be able to sponsor a family member for a green card just based on that family relationship alone. So if someone were to marry a US citizen, for example, that would be the immediate relatives category. So the US citizen could petition for the foreign national for permanent resident status based on that relationship, based on their marriage. Same thing if you have children or if you have parents, if you have grown children, I should say, they may be able to petition for you. Or if you have parents who are permanent residents or US citizens, they could potentially petition for you as well. What we're going to focus on is primarily the employment-based categories. So you see we have 5 categories, this EB1, EB2, EB just stands for employment-based. So EB1 is employment-based first preference, EB2 is employment-based second preference, and we'll talk a little bit about what those mean and what the distinctions are between those. But this kind of gives you an overview of the different categories to go through to get a green card. So within employment-based green cards, this is kind of how the process goes. These are the primary stages involved in the process. We'll start on the left where we say most employment-based cases start here with what's called the PERM labor certification. And I'll talk about that in more detail, what that process involves and what it means. But most employment-based cases and green card processes where an employer is seeking to sponsor an employee for permanent residency based on employment, most of those start with the PERM labor certification. And basically what it is the employer going through certain steps to demonstrate to the US government that there are no qualified US workers available for the position they want to use to sponsor a foreign worker. So in order to sponsor an employee for a green card in most categories, the employer does actually have to show that they've made efforts to see if there are qualified US workers, meaning US citizens or already green card holders, who are interested in the job and would qualify. And if an employer goes through those steps and they have people apply for the job and there are people who are qualified, who are out there and they're US citizens, technically the employer can't proceed with sponsoring a foreign worker. But if an employer goes through these steps and they find that they were not able to find any qualified US workers for the job, then they can get permission to proceed with sponsoring a foreign worker. Once that process is done, the next stage is what's called the visa petition, so the immigrant visa petition. In the employment-based context, it's on Form I-140, so we often call it an I-140 petition. In family-based, it's called the I-130, so they're very similar, just that minor distinction between the two. The visa petition is where the employer is saying, okay, if it's a PERM-based case, labor certification, we've gone through the process, we've shown you that there are no qualified US workers. So now when we're filing the visa petition, here is the foreign worker we would like to sponsor for permanent residency. And here is information about the job opportunity that we're using to sponsor them, the job offer. So that's where the employer sends that information to USCIS to basically put that employee in one of the employment-based green card categories. Now, even then, even after the employers filed the petition and said, we want to sponsor this employee for permanent residency based on employment, even once that's approved, that's not the final step. Really what the visa petition does is it establishes the employee's eligibility to then apply for the actual green card. So the way the employee actually gets their green card and becomes a permanent resident can be one of two ways. The first way, kind of the bottom route here, what we call consular processing, would be if the employee is not in the United States. So let's say the employer has someone in mind they want to bring over. They're not able, for whatever reason, to get a non-immigrant visa for this person to bring them to the US in the meantime, but they want to sponsor them for a green card based on a job offer. So if that individual's outside the US, once the visa petition is approved, the employee would be able to use that visa petition to get an immigrant visa in his or her passport at a US consulate or embassy abroad, and then use that visa to enter the US as a permanent resident. The more common path, particularly for employment-based cases, would be the upper path here called adjustment of status. What that means is, or what that refers to, is a situation where the employee is in the United States. So they're, in many cases, here in the US, working for the employer on an H-1B or some other type of visa. And at the same time, the employer is going through the green card process for them. So if the employee's here, once the visa petition is approved, the employee can submit his or her application for adjustment of status. And they're seeking to adjust their status from a non-immigrant to an immigrant. So from a temporary visa to a permanent visa. That's what the adjustment is. Once that application is approved, the adjustment of status is effectuated, and that individual is then at that point a permanent resident. So USCIS would mail what we call a green card or permanent resident card to that individual. And at that point, they would have been adjusted to permanent resident. So they're no longer in a temporary non-immigrant status. So one thing to keep in mind, and we've got some information here just for your reference, but I won't go into this in too much detail. One of the issues with green cards in most categories is that they are sort of like the H-1B, limited in number each year. And in many of these categories, well, the way they're limited is by category, but also by country of origin. So each category of employment-based green card gets a certain number each year, and each country can only use a certain percentage of those available green cards. So what happens is, in most years, the high volume countries that have a lot of people and a lot of people seeking green cards, they use up their full allotment of green cards. What the US government does in the green card context is they don't do a random lottery like they do for H-1Bs. They do, for green cards, implement a kind of a first in, first out system. So it creates these queues or these waiting lines, these waiting periods that individuals have to wait in, and they cannot finish the green card process until their time in line comes up. So what this results in is basically long wait periods for individuals from those high volume countries. And for employment-based cases, it's typically most often seen with China and India. So individuals who are born in China and India generally have a long wait period before they're able to finish the green card process. And basically how this works is, I'll go back a slide for a second. Regardless of what the quotas or the backlogs say, employers can complete the PERM labor certification, and employers can complete the visa petition, that I-140 petition. What they have to do, though, is once the I-140 petition is approved, if there is a backlog, so if there's a waiting period for that employee based on where they were from, they have to stop. They can't proceed to file the adjustment of status until a green card becomes available to that employee. So until their time in line comes up. So for Indian nationals, for example, we see this very often where an employer will do the PERM labor certification, they'll do the I-140 petition, and that gets approved. But because there's such long waiting periods, they have to stop and wait at that point. And the approval of the I-140 petition basically locks in that employee's place in line, and it tells them where they are in the line to wait for a green card to become available. Once they wait and their time in line comes up, then at that point they file the adjustment status application. Now, the way we determine this, the way we figure out, well, where am I in line, or how long are the wait periods, is we look to a document called the Visa Bulletin. And the Visa Bulletin is published each month by the US Department of State. So what the US Department of State does is they look at the total number of visas available, they look at the numbers that have been used up, and the number of people waiting in the queue, and they give us information that allows us to determine what the current situation is for the wait periods. So what the Visa Bulletin shows is the cutoff dates in the various categories for different countries. So the easiest way to kind of explain this is to just give you an example. So what I've pulled here is a chart that appears in the current month's Visa Bulletin. So this is from November 2020. And you'll see in the first column, we have all the different categories of employment-based green cards, EB1 all the way down to EB5. And if you go to the right of that, we have different columns for different countries. So we have China, El Salvador, India, Mexico, Philippines. In this second column here, we've got worldwide. So basically what that means is anywhere else that doesn't have its own dedicated column next door. So worldwide, we see in all the categories a C, the letter C. What that means is current. Current means there is currently no backlog. So immigrant visas or green cards are currently available in all of those categories for individuals from any country not in one of the countries listed in the other columns. So that's good. That means once you get to the I-140 petition stage, there's no artificial waiting period. The employee can actually right away go ahead and submit their adjustment of status application. But if you look in some of the other boxes for the other countries, these dates appear. So for example, let's look at EB2 for India. So you go down to the EB2 row, go over to the column for India, and we see this date of May 15th, 2011. This is the cutoff date for visa availability. So basically what this is telling me is that in the month of November, from November 1st to November 30th, individuals who were born in India, who are proceeding with a green card in the EB2 category, can only finish the process. They can only file their adjustment of status application if their priority date is earlier than May 15th of 2011. So basically, if their employer started the process for them before May 15th of 2011, then now in November of 2020, they're able to submit that last part of the green card process. But if the employer, if their green card process had started anytime after May 15th of 2011, their time is not yet up, their date is not current, which means they still have to wait. So they cannot yet submit their adjustment of status application. So if you think kind of what that means in the real world, this means if there's someone out there who, let's say, started the their employer started the green card process in June of 2011, they still cannot finish the green card process. So that person has started the green card process over 9 years ago, and they're still waiting for their time in line to come up. So it's only people who started before May 15th of 2011 that can proceed in that category. And looking at the dates, you can kind of see where things stand and how things move each month. So each month, these dates may stay the same. They may advance forward. So this date may go from May of 2011 to June of 2011, or they can go backwards. So it could go from May of 2011 to January of 2011, and actually fewer people then would become eligible. It's all based on these complicated formulas that the Department of State uses to determine. They're basically trying to get the perfect amount of applications in to use up all of the green cards for the year without going over or going under. So they adjust these dates each month to try to keep that on track by the end of the year. So it's important to keep in mind, if you're from India or China in particular, you can see, in addition to the 1 or 2 years that it just takes naturally for anyone to go through most employment-based green card processes, there's going to be an additional wait period for you to have your time in line come up to be eligible. So the date that you use to compare to these, I mentioned the term priority date. That's a date that is assigned to everyone who's going through a green card process. That's what determines your place in the line. So the priority date is assigned to you. I'll go back. Once the I-140 petition is approved, you have locked in your priority date, and the priority date is formally assigned. What that date will be is going to correspond to the date that the PERM labor certification application was submitted. So let's say they filed this application in, let's say your employer starts the process now. They file this in November 2020, takes about 6 months or so. So we get into May of 2021. And let's say in August of 2021, your I-140 petition is approved. You'll get an approval notice in August of 2021 for the I-140 petition. And on it, it will say your priority date is November of 2020. So it is retroactive to when you first started the process, essentially. But that's the date you'll carry with you, and that you'll compare to this visa bulletin each month to see, are you eligible to finish the process and file your adjustment of status application. So we'll go quickly through kind of some of the green card categories. I mentioned the PERM labor certification. We've got some information about it here, but basically what it is a test of the labor market. So again, for most green card categories, before an employer can actually sponsor a foreign worker for a green card based on employment, they do have to show the government that there are no qualified US workers for the job. So the way they do that is there are certain steps employers must take. Essentially, they have to recruit for the job. So employers have to place certain types of advertisements in print, in newspapers, and online, as if they have an open job opportunity. Even if you're currently working in that job, they still have to post it as if it's an open opportunity and see if people actually apply. So as people in the workforce or in the labor market submit applications, employers have to evaluate those and look to see if anyone who's applied meets the minimum qualifications. So it's quite a unforgiving process because it is a minimally qualified standard. So employers are not comparing the qualifications of people who apply to you. You may be way more qualified than anyone who's out there who applies, but that's not relevant for most of these processes. What they're looking at, what the government's looking at, is to see, are there any US workers out there who meet the bare minimum requirements? And if there are, the employer technically can't proceed with sponsoring a foreign worker. There's an exception to that for college and university faculty. So if you're getting an advanced degree and you may go into academia and pursue a teaching position, the standard is a bit different for these processes for college and university faculty. The standard there is a most qualified standard, so it's more forgiving. For college and university faculty, employers do have to place not as many ads, but they do still have to post the position in certain venues. They have to accept applications. And as the applications come in, they have to evaluate them. And in those cases, they can compare them to your qualifications to see who is the most qualified. So even if someone applies for a faculty position who meets the bare minimum, that's not necessarily going to be disqualifying, because the employer can look at that individual, compare it to the foreign worker they want to sponsor, and if they determine the foreign worker is more qualified, they can still proceed with the process, even though a minimally qualified worker has applied from the labor market. So there is that little distinction between college and university faculty versus everyone else, basically. Let's see. So these are some of the main steps, and we don't need to worry too much about these and get into the weeds, but basically the employer conducts that recruitment. If it's successful, they can proceed with sponsoring the foreign worker. All the steps, when we consider all of those, you're looking at about a year or so to complete this process. So there's several months worth of prep work that employers have to do before they can actually submit the labor certification application to the Department of Labor. And once it's submitted, the processing time for it's anywhere from 4 to 6 months or so. So for most employment-based green card processes, it's not immediate. You're looking at 1 to 2 years to complete the process from start to finish. And if you're from China or India and subject to those backlogs, it's going to be even longer before you actually have your green card in hand. Now, I'll go back again, not to jump too much, but we say here on our overview slide that most employment-based cases start with the PERM labor certification, but there are some employment-based cases that go directly to the I-140 petition and do not have to go through that labor market test. And those categories are the ones we've listed here. These categories are exempt from the labor certification, exempt from the labor market test. Basically, what the government is saying here is that these categories are people who the United States wants to be able to immigrate here and remain here permanently, even if there's someone out there who's minimally qualified. So if you have someone who has extraordinary ability, or you have someone who's an outstanding professor or researcher, we don't want to hinder their ability to get an immigrant visa or a green card just because there's someone out there in the workforce who has the bare minimum requirements. We want people who are extraordinary or outstanding to be able to immigrate to the US regardless of who else is out there in the workforce. So these categories do not have to go through that advertising process in the test of the labor market. So the categories are listed here. We'll talk about some of those in a little bit more detail. So the first one, alien of extraordinary ability, very similar to the O1 non-immigrant visa we talked about, that it has to be someone who has extraordinary ability in the sciences, arts, education, business, or athletics. We've given you the definition of extraordinary ability here, but it's basically someone who has sustained a claim in their field. Basically, you're at the top of your field. This is the very small percentage who have risen to the top of the field. This is a very challenging category to get approved, and it really genuinely does require you to be kind of an expert who's well-known nationally, at least within your field. One of the benefits of this category is, even though it's an employment-based process or category, it can be filed as what's called a self-petition. So if you kind of do things on your own, you do independent research, or let's say you have worked for an employer in the US and you want more flexibility, this can be filed on your own. You can serve as the petitioner. You do not have to have an employer petition for you, which you do for any of the ordinary employment-based green card processes. So this is kind of an option for some people who just don't have a formal job offer, but they've had a distinguished career and they want to come to the US to continue working in their field. They just may not know necessarily who specifically they want to work for. So it does have that flexibility. These are, we listed out the evidentiary requirements. So I'm not going to go through all of these, but you can see the types of things that the US government looks for when evaluating if someone qualifies. You have to show that you meet at least 3 of these, but that by itself is not enough. And honestly, even if you show that you minimally meet all of these, that doesn't mean your case will be approved, because that's just a threshold question. So whether you satisfy at least 3 criteria is an initial determination that they make. If that's yes, if you meet at least 3, the next step of the analysis is what's called a final merits analysis, where it's more subjective. The USCIS officer will look at your case as a whole and just make a judgment call as to whether they think you substantively are someone who is in fact at the top of your field. So it requires doing more than just publishing 1 or 2 articles, judging the work of others on 1 or 2 occasions, and being a member of 1 selective organization. So that person would meet 3 of those criteria, but probably not be approved because they've just minimally satisfied the baseline requirements. You really have to do more than that to get approved. Another category that's quite similar to the alien of extraordinary ability is for an outstanding professor or researcher. So these are basically specifically geared towards college and university faculty, though they can sometimes be used for research position at non-colleges and universities. But we see these most for faculty members. A lot of times faculty who either may not have tenure yet, but are probably close to pursuing tenure, because a lot of what they need for that is similar to what they need for the outstanding professor researcher green card category. But again, doesn't require you to show that you're extraordinary here. Instead, you have to show that you're outstanding. At the end of the day, it's similar. The types of things that USCIS is looking for are similar between the 2 categories. So you have to show here that you've made original contributions of major significance to your field. So you've done a lot of research work, you have publications, you've been cited a lot of times, you present at conferences, you're on editorial boards for journals, things like that. And we've got the criteria here. Same type of thing. Here there's 6 categories, you have to meet at least 2 of them. But then in addition, you also have to pass this final merits analysis to substantively qualify and get an approval from USCIS. And the last one we'll talk about quickly is a national interest waiver, which again is along the same lines of the prior two we discussed. It's not extraordinary, it's not outstanding, but here you have to show that you have exceptional ability. So it's really a half step below extraordinary. It does still require you to show that you're above and beyond ordinary workers in your field. So the analysis they use is to determine if you're well positioned to advance work in your field of endeavor. So if you're someone who has made significant contributions to your field in the past and obviously able to continue doing that in the future. The additional component here is just that you have to show your work is in the national interest of the United States. So whatever field you are working in or intend to work in is a field of national importance. So, this is pretty flexible. It really can be a lot of different things. If you're in the medical sciences or you've done research on cancer drugs or you have researched some sort of important environmental issue, or you're an engineer and you've done critical infrastructure work for the US. So it's pretty flexible. There's no specific field that they're looking at, but you do have to show that what you're doing does have some importance or interest to the US as a whole. Like the alien of extraordinary ability, this also can be filed as a self-petition. So you can file it on your own. It doesn't require an employer. Even if, sometimes employers don't want to go through this process. It's just too much expense and time for them. So they're willing to have to work with, employ someone, but they don't want to go through all these steps of a green card. So the national interest waiver, like alien of extraordinary ability, would be one that you could actually do on your own without the employer needing to sign off on anything. So that's typically where our formal presentation ends. Now I've got a few slides here that I'm going to fly through really quickly, but I've added them here mostly as a resource to you. So the slides will be available to you all after the presentation. You can kind of go through these at your convenience to just get some information about what's going on now or has been going on the last few months. But I just wanted to, like I said, include these as a resource so you're aware of what's going on and kind of before you make any decisions or do anything, you can plan accordingly to make sure you're not going to get yourself in major trouble. So what these last few slides focus on are various executive orders or presidential proclamations, they're called, that President Trump and his administration have published or put out basically since March or so, when COVID-19 started expanding and the pandemic was growing and growing. There were a lot of immigration-related changes that came along with that. The first, and this slide right here kind of outlines the different types of orders and proclamations that have been put into place. So there's several orders that restrict travel based on physical presence in certain countries. So, for example, in January, the president issued an order that said anyone who has been physically present in China within 14 days prior to their proposed travel to the US cannot travel to the US from there. That's been expanding and expanding to include more places. So Iran was added in February. In March, the entire Schengen area of Europe, which is almost all of Western Europe, was added. Then the UK and Ireland, and most recently Brazil. So all these countries, the proclamation says anyone who has been physically present in any of those countries within the last 14 days cannot travel to the US. There are some exceptions, which we've got slides on those, so you can kind of see what exceptions are available. But as a general rule, what this does is it prohibits travel from those countries to the United States, absent some sort of exception or a way around it. The other type of proclamation or order that has been put into place is related to actually issuing visas at US consulates or embassies abroad. So in April, there was a proclamation that suspended the issuance of immigrant visas. That mostly affected family-based cases. So a US citizen who had petitioned for a family member abroad to bring them here. Those immigrant visas have been put on hold. You can't get them right now, absent some sort of exception. In June, there was a separate order that impacted certain non-immigrant visas. Now, this was focused primarily on H visas, so H-1B, H-2B, which is probably not one you'll encounter. J1, some types of J1 visas, and L1 visas, which are for intra-company transferees. So a company abroad seeking to transfer an employee to a corporate entity in the US. But the H-1B was the big one. So basically, when that proclamation went into effect, anyone who needed to get a new H-1B visa in their passport after June was unable to do so, and still is unable to do so unless they qualify for one of the limited exceptions. So there's more information about these. I'm kind of skimming them to see if there's anything I want to just highlight. One thing I'll mention about the geographic proclamations, so the ones that say if you've been in any of these countries, you can't travel to the US. They say if you've been there within the last 14 days, you can't travel to the US. So even if you have a valid visa, you have a valid unexpired visa, let's say you go home to London for Thanksgiving break and you want to come back to the US, you can't do that because the UK has that travel ban, basically. Even though you've got a valid visa, that's not the issue. The issue is this restriction on travel. So you either have to qualify for an exception, or one thing I've had some clients do is travel to a country that's not in any of these lists. So Turkey, for example, as someone who went back to London, back to the UK, can't travel to the US from there, so they'll go to Turkey, wait out the 14 days, and then travel from Turkey to the United States, because at that point, they would not have been in any of these affected countries within the 14 days prior to traveling to the US. So this has created some kind of weird situations. I've had employers send employees to the Bahamas and Jamaica, countries in the Caribbean that aren't affected, and they kind of just wait out the 14 days there, which I guess could be worse. There's worse places you could go for a couple of weeks. But basically it's become this huge puzzle that you have to deal with these travel restrictions. And if you're going to need a new visa, you also have to deal with the visa restrictions as well. So we're going through some of the exceptions here, and I'll just leave those for you to review at your leisure. The immigrant visa proclamation, the non-immigrant visa proclamation. So here the visa types that are affected and some of the exceptions available. Now, one thing to just clarify and keep in mind, and we got a lot of questions about this when this proclamation first came out, this proclamation just relates to issuing visas abroad. So going to a US consulate or embassy in a foreign country to get a new visa in your passport. This does not affect eligibility for a change or extension of status in the US. So if you're on an F1 visa and you're on your OPT and you then get an employer who wants to sponsor you for an H-1B, there's no issue with you changing to H-1B status from within the United States. This proclamation does not impact that at all. This is just people who are outside the US or traveling outside the US who need to get a new visa in their passport to re-enter. Some of the exceptions to that one as well. And so we'll kind of just wrap up the formal presentation here. I always like to include these resources just to guide you if you're looking for more information. These government websites, ICE and USCIS, are pretty good in terms of laying things out in a format that's easy to understand. NAFSA is not a governmental organization, but it's the Association of International Educators, who they deal with a lot of student-related issues in the US, and they always have great summaries of recent changes in the law, proposed changes and things like that. So I myself often look to NAFSA to get kind of summaries, quick summaries of things that are going on. So it's always a good place to look. Obviously, the VIS office is a great resource you all have on campus. They're very knowledgeable. They're very good at either helping you with things or directing you to somewhere where you can get further assistance. And sometimes that does involve an immigration attorney like me or many of the other great immigration attorneys we have here in New York. You know, upstate New York, downstate, there's a lot of great practitioners. So if you're looking for case-specific advice or, you know, changes to different statuses after that, obviously consulting with an immigration attorney, especially nowadays, you know, I'm not just trying to plug myself here, but, you know, it makes me very nervous when people try to do things themselves these days, because immigration, people always say immigration law is the second most complicated area of law we have behind tax law. And sometimes I think immigration is the most complicated, just with how quickly things change. Overnight, longstanding policies can be gone and things can totally be revolutionized in the way of how they're being applied and what the rules are. So I think it's always good to seek advice from any of these resources before you take any steps or make any significant plans for kind of what you're going to do from here. But I have my contact information here. We've got some time for questions, so I'm happy to answer as many questions as I can. But if you have additional questions after the presentation today, my contact information is up on the screen now, and you're welcome to contact me to discuss your case or any assistance you might need.
Great. Thank you very much, Brendan. Everyone, please join me in giving Brendan a virtual round of applause, and we thank him for generously donating his time today. So we are going to go through some of the questions that were submitted. We're going to go in order of questions that were submitted. As a reminder, the question and answer that we're about to do is general questions. So if you do have any further questions about your specific situation, please contact your VIS advisor, who may refer you further to an immigration attorney. So with that, we will go ahead and dive into the first question. Our first question is wondering, are graduates from medical schools considered specialty occupations for H-1B medical residency?
Yes, so generally medical residents or fellows would qualify without much issue for an H-1B. We work on those quite often. So that specialty occupation wouldn't be a major issue there. One issue that has very recently, within the last couple weeks, become an obstacle for some medical residents to do an H-1B is the prevailing wage requirements. So I mentioned for H-1Bs, there's a certain wage amount that employers must pay to H-1B workers called the prevailing wage. What's happened a couple weeks ago now is the Department of Labor adjusted how it calculates those prevailing wages. And the result has been the prevailing wages now, as compared to 3 weeks ago, are way higher, in many cases unsustainably higher. So there are certain instances where the prevailing wage for physicians has gone from an amount that residency programs can handle to an amount that they absolutely cannot afford to pay medical residents. It wouldn't, there's no logical basis for it. So it's a kind of a complicated issue. A lot of us immigration attorneys are dealing with right now. That's one thing that's made it more difficult very, very recently to get H-1Bs for medical residents. In some cases, there's some cases where you can use a different wage calculation to still make it work. And the new wage levels are currently being challenged in court. There's at least two lawsuits that I know of pending that are challenging that lawsuit, and we're actually expecting a decision on one of those any day now. So to answer the question, yes, medical residencies and fellowships generally would qualify as a specialty occupation. but there's other considerations that may need to be worked through for an H-1B to work there.
Okay, thank you. Next question. Will the numerical allotment of H-1B visas be expected to change over time?
We've been holding out hope for that forever. It really hasn't changed in a long time. It's always something that's tossed around as an idea. And, I think certainly under the current administration, that's not something that would happen. It's possible it's something that could be discussed under a different or under the new presidential administration. But as of right now, there's not really any solid plans in place to have that number expanded, which is really unfortunate because if you look at the data, if you have 5 straight years of 200,000 people applying for 85,000 visas, you would think that shows there's a demand there and there's a need that the current allotment doesn't satisfy. But H-1Bs are a very, very political issue. There's different views on those, whether they're filling a need in their workforce or whether they're taking available jobs away from U.S. workers. People have different views on that. So it's kind of a hot button issue that's difficult to get legislation passed to increase that number. So it hasn't happened yet. I would love if it would someday, but I don't know how optimistic I am that would happen.
Thank you. Next question is relating to the O1 visa type, whether artists and musicians qualify under that visa type.
Yes. So the information I have on the slide is about it's focused mostly on what we call O1A visas. So those are extraordinary ability in sciences. There is a different subcategory called O1B, which is for performing artists. So musicians and artists would be under the O1B criteria or category. The specific categories of evidence are a little bit different because it's performing arts versus research and science. But the ultimate inquiry is the same. You have to show you're someone who obviously has extraordinary ability and is well known in your field. So for example, I just did an O1B a couple weeks ago for a young adult novelist. So he's written books, he's won awards and been interviewed and things like that for his writing. So that would be O1B because it's basically an artist as a writer. But yes, there is a category available for that.
Thank you. The next question, can you please describe the difference between the visa petition process and how that's different than adjustment of status?
Sure. So I'll go back, refer to the slide. So the visa petition is kind of a prerequisite to the employee or the individual filing for adjustment of status. The visa petition, once that's approved, that has no impact on the individual's actual immigration status. So if someone's here on an H-1B and they're working and their employer is going through a green card process for them, and they file the visa petition and that gets approved, that employee is still in H-1B status. Nothing has changed about that employee's status. What the visa petition does is it establishes the employee's eligibility to apply for adjustment of status. So it's kind of the vehicle that the employee can take to be able to get to apply for adjustment of status. Adjustment of status is actually what changes that person's status from a non-immigrant like H-1B to an immigrant or a permanent resident. So a visa petition is basically just the legal prerequisite. It establishes eligibility. It slots that employee into one of the various employment-based categories, but it's only half of the process. The other half to actually get them the status they want is to file for adjustment of status.
Thank you. The next question we have is, Does the green card application wait period apply to all positions? For example, would it apply to research faculty or professorship at an academic institution?
So the wait period is going to depend on two things, primarily country of origin, or a country, what we call a country of chargeability, which is in most cases going to be the country where the applicant was born. And that's kind of an important distinction too, because I've seen a lot of clients, for example, who were born in India, but later became Canadian citizens. They don't get to benefit from their Canadian citizenship for visa wait period purposes. So when someone later becomes a Canadian citizen, they don't move over into the worldwide category. It's still based on country of birth. So first factor is country of birth. The second factor for determining the wait period is which employment-based category they fall into. So all of those labor cert exempt categories I mentioned, the alien of extraordinary ability, outstanding professor or researcher, national interest waiver, or sorry, just the first two, the exempt ones, extraordinary ability and outstanding professor, those are in the EB1 category, employment-based first preference category. National interest waiver falls in EB2, employment-based second preference category. All the other processes or types that are based on the PERM labor certification are going to depend on what the requirements are for the position. So for example, if an employer sponsors you for a green card based on a job offer, and that position requires anything greater than a bachelor's degree plus 5 years of experience or a master's degree. So if it requires a PhD, if it requires a master's degree, if it requires a bachelor's degree and 5 or more years of experience, then that position will fall into the EB2 category as an advanced degree position. If the position they're sponsoring you for requires anything less than those requirements, so if it requires, let's say, a bachelor's degree and 4 years of experience, or an associate's degree, that's going to be in the EB3 category for professionals. So if it's a research professor, research assistant professor position, it's going to depend on whether you're going through EB1 as an outstanding professor or researcher, or if you're going through EB2, the normal employment-based process where you go through the PERM labor. So let's say you're someone who's not quite outstanding. We think they're probably not a strong case in EB1 as an outstanding professor. So the employer just goes through the ordinary employment-based green card process for them. If it's a faculty position, that's most likely going to require at least a master's degree, in many cases a PhD. So that's going to be an EB2. So you have to look at the type of position, see which category it falls into, and then see the country of nationality. And that's how you determine what the wait period is going to be.
Okay, thank you. In the interest of time, we do have time for one last question, which I think is a perfect question to wrap up our session today. The question is, at what point within the immigration process is it advised to establish contact with an immigration attorney, assuming an employment-based pathway?
I would say as early as possible. The earlier the better, because that leaves open the greatest number of options for you. If you wait till, you've got a job off, I would say once you've got a job offer and you have a position in line that you're thinking of or you've accepted, if your employer is not already working with an immigration attorney, they should consult with one at that point. But sometimes you can get OPT and you start working for you. So you've got that full year of work authorization and you think a year is a long time, but you get 6 or 7 months into it. And then you realize, okay, I've got a few months left. Now we've got to figure out what to do. The longer you wait, the more the options narrow, I would say in general, because a lot of this is timing based, and Sometimes there's things you can speed up by, for example, paying more money to the government, but sometimes you can't. So by waiting too long, you may foreclose certain options that potentially would have been available to you earlier on, and certain backup options. So you could say, well, we'll try for an H-1B in the lottery, but if that doesn't work, we have this backup option we can pursue as well. So I would say, if you're graduating and looking for employment-based visa options, as soon as you locate identify the position you're going to take, if you get an offer of employment and you're negotiating with the employer, or you're in the process of accepting and taking that job, that's a good time to start thinking about it, just to see what your options are going forward, because there's not necessarily always one path that you have to take, or may be able to take. So I would say generally the earlier the better.
Okay, so that is going to wrap up our session today. Once again, please give Brendan a virtual round of applause. We also want to thank him and all of our attendees for their time today. And we are going to go ahead and end the session. As a reminder, you can always follow up with your VIS advisor for any further questions. Thank you and have a great day, everyone.
Thank you, Brendan.
Thank you, everyone. Thanks for having me.
Thank you. Take care.